We're very pleased to be joining forces today with two partner organizations, with the Center for Human Rights and Humanitarian Law at American University Washington College of Law, and with the Crimes of War Project. And they have been working side by side with us in putting together this program, and our great colleagues in many efforts to promote greater understanding of international law. We have today as a moderator of our program Christine Husky, who wears many hats and has affiliations with all three of the co-host organizations. Christine is a consultant on international security law, formerly a professor at the University of Texas, and from my perspective, very importantly, the co-chair of the Society's Women in International Law Interest Group. So without further ado, I'll turn it over to Christine to introduce our panel and tell you the rules of the road today.
Okay. Thank you. Well, it's my pleasure. Can you hear me? It's my pleasure to, and great honor to moderate this discussion and briefing regarding the International Crimes Tribunal of Bangladesh, which just in the last year has been gearing up to try individuals for, among other crimes, war crimes, crimes against humanity, and genocide, which occurred during the 1971 War of Liberation from Pakistan, ultimately resulting in the independence of Bangladesh. But there has been concern, both within Bangladesh and internationally, about the tribunal's statutes, rules, procedures, and practices, and even a related constitutional amendment. Ambassador Rapp visited Bangladesh twice this year to address those concerns. So we look forward to this briefing and the following discussion, but let me start by introducing our main speaker and our other esteemed panelists. Stephen Rapp is the Ambassador at Large for War Crimes Issues at the State Department. Prior to his appointment in 2009, Ambassador Rapp served as prosecutor of the Special Court of Sierra Leone and led the prosecutions of former Liberian President Charles Taylor and others for atrocities committed during the civil war in Sierra Leone. He achieved the first convictions in history for sexual slavery and forced marriage as crimes against humanity, and for attacks on peacekeepers and recruitment and use of child soldiers. From 2001 to 2007, Ambassador Rapp was the senior trial attorney and chief of prosecutions at the International Criminal Tribunal for Rwanda. And Ambassador Rapp was also a U.S. attorney and the staff director of the U.S. Senate Judiciary Subcommittee on Juvenile Delinquency and an elected member of the Iowa legislature. I did not know that. Over to my right is Caitlin Reiger, director of the International Policy Relations at the International Center for Transitional Justice. She previously, Ms. Reiger, was the deputy director of ICTJ's prosecutions program and led its work in Cambodia and the former Yugoslavia for several years. She's provided advice and policy analysis to post-conflict justice initiatives and hybrid tribunals in many countries. For several years, she was the judge's senior legal advisor at the Special Court for Sierra Leone. She's been a professor at New York University and has published widely, including a book called Prosecuting Heads of State. To my left is John Kamei, who is a criminal defense attorney with the firm 9 Bedford Row, located in London. Mr. Kamei specializes in cases involving violent crimes, drugs, proceeds of crime, and sexual offenses, and has extensive experience before the courts. For several years, he was the lead counsel for Sierra Leone's notorious rebel leader in the trial at the Special Court of Sierra Leone. So you all have something in common. Mr. Kamei returned to the UK full-time in 2009 and has resumed his domestic criminal practice. He is also a lecturer on international criminal tribunals, law and process at the London School of Economics. And without further ado, I turn it over to Ambassador Rapp.
Well, thank you very much, Christine, and thank you, Betsy, for the invitation. It's an honor to be back at Tiller House. I think I was here twice in 2010 talking about the ICC process, and great to be here with John Kamei, who is involved in our cases in Sierra Leone, and Caitlin Rieger, with whom we're involved, my office, with so many issues regarding transitional justice. First of all, as I begin my comments, I want to basically explain why why our government of the United States accepted the invitation of Bangladesh and its government to go there in January and to and to observe the situation with the International Crimes Tribunal, and to seek out input and advice and comment from, as we did, from the government, from the judges, from the prosecutors, from victims, from defense attorneys, from the bar, from other judges, from members of the political opposition and their party leaders. Why we proceeded in March to make recommendations on ways in which we believe that the procedures could be improved. And those recommendations were indeed also made at the invitation of the government of Bangladesh, and why I returned there earlier this month to follow up on the progress of the ICT and on what was happening in terms of the recommendations that have been made by my office and also by others. And I want to make the point that really there are three interests that we have here from the point of view of the United States government. And the first is that we believe in justice and in the enforcement of international humanitarian law. And it is extremely important that the victims of these crimes that were committed in 1971, that their suffering and be recognized, that the truth be revealed, and that those responsible be held to account. And certainly, as I was there and met with people who were victims, as I visited the Liberation War Museum, it's clear to me that hundreds of thousands of people still alive in Bangladesh were profoundly affected by the crimes of 1971 and cry out for justice. And we want to help meet that need through a fair and just process where the guilty will be found guilty and innocents won't suffer. Obviously, that process can't prosecute everyone responsible, but it's our experience that appropriately chosen cases in terms of representative events, that a process like that can be very valuable in terms of achieving justice for those victims and allowing societies to reconcile and go forward. Secondly, because of our commitment to the principle of complementarity. Of course, that's a principle we began to talk about with the establishment of the ICC, but it's always been there, and that is the idea that justice delivered close to home, if it can be with independence and appropriate capacity, is the best justice. And even with current crimes, we're constantly, as we are right now in the DR Congo, pressing to establish courts. Sometimes they have to have international participation and assistance, but to try to do that at the national level. And of course, people say, well, isn't this for crimes that are just happening or crimes that happened before 2002? And I think, as our friends from ICTJ and my friend David Tolbert often points out, sometimes it takes a very long time for a country to be able to confront these crimes, and that it's rare that it's done well and effectively very early on. But the demand increases for this to occur, and we've certainly seen in Germany in the 60s and thereafter, in Latin America, even 30 years and more after the Guerra Sucia, great demands for justice at the national level, and meeting those demands in an appropriate way is key to establishing justice at the national level. I know people can say, well, didn't they do something afterwards? And in a few cases you've got, like in Cambodia, they had a show trial of certain leaders. In this country, in Bangladesh, there were even actions against accomplices. But those often weren't focused. Indeed, the ones in Bangladesh weren't focused on war crimes. They were focused on complicity or collaboration with the forces that worked against the liberation of the country. And in the end, I think a lot of people were convicted, but only one was executed. In the end, there was a reprieve for everyone and a pardon. And that was appropriate. Those kinds of crimes that involve political acts or being on the wrong side of a civil conflict, those are appropriate cases to be amnestied. What shouldn't be amnestied is the violations of international humanitarian law, but developing the capacity to prosecute those cases can take time. And finally, this is an opportunity in a region of the world where there hasn't been a lot of action, frankly, to enforce international humanitarian law norms, to see it done. On the trip that I was just on, I spent time as well in Indonesia and in Philippines and in Malaysia, talking about the establishment of an International Commission of Inquiry for Burma. And that's not particularly a hospitable territory to press for that idea, but we're deeply concerned about the ongoing violations of IHL. Human rights violations, to be sure, but IHL violations, forced labor by the military, rape and murder in the civil conflict with the Karen and the Shan and other groups, the ways in which the Rohingya are persecuted and forced into Bangladesh and into leaky boats and into refuge, in fact, not even given the status of Burmese citizens. These are issues that we'd like to see the truth revealed, and some measure of accountability. And right next door, we have an opportunity where a country is developing a process of accountability. And we've seen internationally with, for instance, the ad hoc tribunals. It was the case, it was the work of the Yugoslavia Tribunal bringing us Milosevic to trial, and of the ICTR bringing Prime Minister Kambanda of the genocidal government and convicting him of genocide, and the Special Court for Sierra Leone bringing Taylor to trial. It was that created the expectation of justice elsewhere and the demand for it. And so to the extent we can get out there and be involved in developing a process in one country, it helps, I think, spread the idea that justice should be universal. Now, in regard to the approach that the American government has taken in answering the invitation of the Bangladesh government, we made it clear from the beginning that we understand this is not an international tribunal, though I know it has this ambiguous title, International Crimes Tribunal, because these are international crimes. This is a domestic process. We also understand, as we have to always when we deal in modern situations of complementarity, that when you try cases at the national level, you are not going to try them in the same way that you're going to try them at The Hague or Arusha in courts where each trial costs $20 million and in which judges are under Secretaries General of the United Nations and in which you have enormous resources committed to each case. That's not realistic, and that's not what the world requires. It requires that certain basic standards be followed when you prosecute these cases. But also, in terms of our approach to the government, our position is that if international standards are applied, this will make the resulting process so much more meaningful for victims, and so much more significant in the decades, in the centuries ahead. To have a fair process in which the truth is judged, in which the advocacy on the side of the defense is enabled to challenge the evidence and to present every argument, and then for the truth to come out, in many cases for individuals potentially to be convicted despite all of those protections being provided, is in the end a much more durable result. And also, observing international standards in this process ensures that if there is, as there is inevitably in our country and every country, a change in the party of government, the process that's perhaps then ongoing won't stop or be discredited. That everyone will understand that this is a fair and just process and can recognize it accordingly. And if you don't have that, you run the risk that the investment that's put into it won't have the benefits for the victims that we really seek. Now, to talk generally about the approach that I took, and understand that in my discussions with the foreign secretary and foreign minister, but particularly with the law minister, it was understood that this process, people had certainly already, at the point that I was there in January, 6 people had been arrested. Processes were ongoing. It was necessary to make the improvements that we sought as soon as possible. That the business of going back and attempting to change legislation or change constitution would necessarily delay the process with adverse consequences, and that I should try, to the extent that I could, because it would be so impractical to do those things, to focus on changes that could be made to the rules. Now, in saying that, and that's what I did, you know, it's we didn't release it. I don't know who did, but you know, it was the 10-page letter that I sent to the government on March 21st was published, I think, in the New Age sometime in April, as was our 49-page addendum, and it's accurate. That's what we sent. But if you saw that, I also said that the things that we were seeking there, we're attempting to do in the context of rules. But if it were found that these changes, if the goal that we sought, the protection that we were pushing for, couldn't be accomplished by the rule change, if the rule in the end were to be held invalid because it was contrary to statute or a constitution, then it was important to look at what kind of changes could be made at the statutory level to ensure that these protections could be achieved. And of course, and as my friends in the legal advisory's office who had to clear on my memo and were saying, you know, it's not for us to talk about other people's laws, we generally don't. I mean, we don't, in making the suggestions that we did, couldn't purport to be experts on Bangladesh law or what the best way is to accomplish these ends. And so the approach we took is looking at specifically rules and the provisions of those rules, and there were several other sort of practice-related areas, and to see, and particularly to ask Bangladesh to consider things that they had already accepted by reason of their ratification of international treaties and conventions, or by reason of their support and participation in international tribunals. And among the people that I saw when I was there is former ICTR judge T.H. Khan, who is a prominent judge at the ICTR in its early days, and made a particularly important ruling contrary to the prosecution, on which he was completely right, and I praised him for it. And I noted as well that the investigator, my investigator that put together the media trial, the trial that resulted in the first convictions in human history for direct and public incitement to commit genocide by the media, was Kaiser Rizvi, a Bangladeshi police officer who had gone to Unimir in Rwanda, had then proceeded to the ICTR, and at the time that I finally was able to lead his testimony, was working on the Milosevic team at the ICTY. So Bangladeshis have been involved in each of these tribunals and have recognized the way that they've done the work. And so I said, let's look at some of the provisions that these other courts have and practices that they've followed, and look at the ICC as well, because Bangladesh, unlike the United States of America, has ratified the ICC this last year, and so it's appropriate to look at the documents, the founding documents of that court as well. But first and foremost is to look at the International Convention on Civil and Political Rights, which Bangladesh ratified in 2000. And make sure that the practices and procedures followed by this court, observe those standards. And indeed, if you've seen my letter, it said, I proposed, I think that try to avoid quoting myself, but in any case, as I said, consideration should be given to the adoption of a rule that would provide that without prejudice to the enforcement of greater protections provided specifically by the Constitution of Bangladesh, the International Crimes Act as amendment, and the ICT Rules of Procedure, all persons under investigation and under formal charge shall be entitled to those rights set forth in Part 3 of the International Covenant on Civil and Political Rights. So, and indeed, I mean, many of those rights are already in provisions, but this just ensured that they would be there. Beyond that, though, I thought it important to look at ways in which the other tribunals had dealt with some of the issues that had been frankly raised already in commentaries by the defense at the ICT, by the International Bar Association, and to look at what had been done in those rules on questions of presumption of innocence, burden of proof beyond a reasonable doubt, the regulation of pretrial detention. And of course, one of the concerns that I certainly have and expressed was the fact that people had been detained for lengthy periods of time without formal charge and without the sort of periodic review that's provided even in civil law systems, where people are sometimes detained for extensive periods of time, as they were at the extraordinary chambers for the courts of Cambodia before formal charge. But there are still certain protections that had to be observed and provided, suggesting, for instance, on that one, that they could look at the approach of the more common law tribunals that allow for extensions and periods of time to indict, subject to review of detention when that occurs, or to the procedure followed, for instance, at the extraordinary chambers, where there's an ability to extend the investigation, but also a requirement that every 4 months the matter of the person's treatment and detention needs to come back before the judges. Then the other issues included the questioning of suspects, both during the investigative stage and further on after formal charge, disclosure of key evidence, and because it relates so closely to it, but also is much broader than it, the question of protection of witnesses. Courts at the international level have become involved in providing extensive protection for certain witnesses whose the publication of their identities would subject them to threat, and sometimes that causes limitations on the right to disclosure, redacted disclosure being made to the defense until relatively prior, or to the prosecution until relatively shortly before the testimony, to prevent the witness from being harassed before the witness is put under formal protection. But that that disclosure and related to it witness protection, but also a potential regime for witness protection and anonymous testimony should be considered, and suggested rules that could do that. Those are, as I should note, the letter, as you've seen, has been delivered. In terms of the government response, all I can say is that in my visit in early May, people were very favorable and said, we're going to really try to take this on board. The idea that they're going to take 100% of it on board, I don't think I got that communication. But the impression was that they would find a way to satisfy each of these concerns consistent with the approach that I had taken. And that's the message that I received. And I think we want to continue, and we are continuing to work with the government and are ready to assist them with that. I will say there are some other things here that go specifically outside the rules, the classical rules, in terms of my suggestions. One has to do with the crimes themselves, and it's often been suggested that the 1973 law needs to be amended in order to update the definition of the crimes. And of course, doing that in a statutory way is a little difficult without running the risk of violating principles against retroactivity. and as you read my letter, there was a lot of discussion on retroactivity, and there's a national dimension to this as well as an international. But at the international level, it's important to note that generally you can't pass a law after the crime is committed. But there's an exception in the second paragraph of Article 15 of the ICCPR, which says that you can, to reflect essentially international law at the time that the crimes are committed. And so it was entirely legitimate for Bangladesh, as a matter of international law, to pass a law in 1973 to criminalize crimes against humanity or war crimes or genocide committed in 1971, to the extent that that law reflected the extent that statute reflected the laws that existed in 1971. There's a bit greater temptation, if you were doing this in 2011, to try to bring it up to date and add things that weren't there in 1971. And that's one of the dangers of statutory change. And frankly, what Bangladesh had done in 1973 is they had gone to the only source there was for this law, and that was the Nuremberg Charter, signed the 8th of August, 1945 by the victorious Allies in London, that had been the basis for the convictions at Nuremberg and thereafter in the subsequent proceedings. There's a few modifications to that, and there may be significance, and I'll be glad to talk about those modifications. I see the reason why they were there. But it's true that that's where the idea of crimes against humanity involving attacks on civilian populations originated, and from that foundation, one has built over the course of the intervening decades provisions like those in the Statute of Rome. What I suggested could be a solution to this problem was, to the extent that the crimes were described in that statute of 1971, for instance, murder as a crime against humanity, one could then, for guidance on what the elements should be, look to the elements of murder as a crime against humanity before the ICC, and as long as one did not do that in a way that disfavored the accused. In other words, if that provided greater precision, so you'd be able to say that the attack on civilian population has to be part of a widespread or systematic attack, it has to be part of an organizational or government plan or policy, that you read those in, because those, I suggest they were already implied at Nuremberg, but that you read them in, that provides greater precision for the prosecution and defense. And as long as you don't criminalize something that wasn't criminal at Nuremberg, I don't think you violate anybody's rights. Now, this is an imperfect solution, but when I was there in May, I asked the chief prosecutor what he thought of this. He said, great idea. Now we know how to indict. And I saw a barrister, Rasak, who represents certain of the accused associated with the Jamaati Islami Party, and he said, great, that's a good suggestion. So it may not satisfy the desire of people to have a perfectly looking statute, but it may allow us to define those crimes in a way that allows cases to go forward and for parties to clearly understand what they have to prove, or what they can, by knocking down the proof on one of them, do to avoid conviction. There are other factors that I brought up that don't go specifically to the statute or to the rules that I thought were equally important, and they're at the end of my letter. And the first of these had to do with a foreign consul. I do think that during the course of the last 15 years, enormous experience has been built up on both the prosecution and defense side about actually how you try these cases. And I think both sides, the prosecution and defense, could benefit from that international experience. I know the defense really wants it, and there's some very good defense attorneys like my friend John Kame, who's here, and Toby Cadman, who's here with him, that I think will be a we'd be very formidable foes in these trials, and that's all the more appropriate. Bring it on in terms of defense if you want to do this right. And so I think it is important that there be defense counsel allowed to participate. Now, if you go to other countries that have had international crimes courts within the national system, if you go to, of course, to Bosnia, where Toby was a prosecutor, you got defense and prosecution counsel on people on both sides that have come from international levels. If you even go to Rwanda, often criticized, but in Rwanda, international counsel regularly appear in their classical justice system and simply have to stop in at the bar and register, something my friend Peter Irlander didn't do, by the way. But if you stop in and register and you associate with the local Rwandan defense counsel, you can participate in their classical system. And so there's precedent for doing that. And of course, in most Commonwealth countries, I was with my friend, the former prosecutor, my predecessor as prosecutor of Special Court for Sierra Leone, Desmond de Silva, and he's represented people all over the country in English-speaking courts, or courts that rose out of the Commonwealth. And so I think there's a tradition of being able to do it, except in Bangladesh. And at least since proceedings involving the founder of the country, Sheikh Mujib, before independence, as I understand, there hasn't been actual counsel appear, and the bar counsel takes the position that under the statute, this can't under the statute, not of the tribunal, but of the bar. The bar says advocates of the bar and the senior bar of Bangladesh need to be nationals, need to be citizens of Bangladesh. I raised with the judges of the tribunal, well, you don't have to say that only advocates of the bar of Bangladesh can appear. You can write a rule, and you have already, that says, yes, we can have international counsel, but to the extent approved by the bar council. You can take that line out. You can decide who's qualified. I think there's some reluctance to do that, but I think it would be important, and I also think it's important for the prosecution to have the right to call up people. I could recommend some to join them in putting these cases together from the other side of the table, and so I think that's important. Now, it may be that this won't happen, and if it doesn't, and I think it's important that it happen. There was some discussion of a halfway solution, which won't please John or Toby, which was that people could be part of defense teams as legal advisors or advisors to the prosecutor that wouldn't have rights of audience but could sit there. And that would also make sure that their right to be in the country was clear so that they could get visas to be there to participate. But there is consideration being given to this issue. Other issues include the death penalty. I represent the government of the United States. I think 36 states and the federal government have the death penalty. We don't make it a condition of our assistance for the rule of law programs that a country abolish the death penalty, and obviously we assisted the international, the IHT, the Iraqi High Tribunal, that dealt with the regime crimes of the Saddam era in Iraq. But I do note in my submission that in terms of getting the kind of international assistance from EU countries, from the United Nations and others, it would be a very useful thing to eliminate the possibility of the death penalty in these cases. And that's a clear position that I sent from my government to the government of Sierra Leone, or government of Bangladesh. The next point had to do with prosecution strategy. And I think this is very important, and handling this one right, I think, can relieve a lot of people's concerns. All of us that have been international prosecutors know we can't prosecute every case. And even national prosecutors know you can't prosecute every case. So how do you pick them? And when you pick them, how do you explain what you're doing? And it is absolutely necessary that anyone doing these kind of crimes be able to stand up in a public session across the country and say, this is my strategy. This is the approach that I'm taking. This is why I'm selecting cases. These are the factors in terms of gravity, in terms of level of offenders that I'm looking at. The prosecutor of the ICC has published these kinds of guidelines, and you can read about them in terms of what he does. It's a little less common at the national level. Of course, in the United States, if you want to read the U.S. Attorney's Manual that's on the web, you can read about how we make selections for cases at the federal level in the United States. But the point is, not every case is going to be prosecuted. There are indeed hundreds, if not thousands, of people that could be implicated in the crimes that were committed here that are available for arrest and prosecution. They live in Bangladesh. How do you pick the people that you're going to go after? And unless a prosecutor is prepared to answer that question, unless you're prepared to say what the strategy is, I think you've missed an important lesson in terms of how one proceeds with international crimes and how one then does something that will stand the test of time. That also relates to the outreach issue, which is I was proud to be involved at the Special Court for Sierra Leone, where I came on as the third prosecutor and where all of this had been done and created before I arrived. But the best thing about that court is that we employed 13 outreach coordinators across the country that they conducted, they claimed, and they had lists of how many contacts, and they would show that they had made 7,000 sort of outreach events in a single year in different organizations and meetings. We had mass meetings where prosecutor and defense answered questions about what we were doing, et cetera. And school children and adults and victims and people's hands have been chopped off came forward and challenged us on what we were doing. This is an extremely important part of this process. Now, people say, we don't need that here, the press, and I must say every time I've never felt more popular with the press. I mean, at least more of interest to the press, let's put it that way, than I've been in my life in Bangladesh. I mean, everywhere I went, I had 30 or 40 reporters following me, so there is a lot of press attention in it. But it's not enough just to do that. The court itself needs to have to ensure that its judgments are out there on the web, that its proceedings are available not just to people that come to Dhaka and go to the courtroom. And it's that kind of fishbowl that you need if you're going to have a meaningful process, particularly because at the end of the day, as we had in Sierra Leone, we only prosecuted 13 people. And you had thousands of people that were involved in these crimes. People had to understand the importance of those cases and hear that testimony and listen to the evidence and to the decisions that were made. And so I think this whole business about making sure that everything that the court does is available, at least to the public, if not affirmatively spread in the country, is an absolutely key part to having a meaningful process. Anyway, those are the suggestions that I made, and I was very pleased that they were well received. However, this is still a work in progress, and we're not leaving the field. I'll be back to Bangladesh many times to ensure that the government and the people's desire for the best possible process is aided by us. So thank you very much.
Thank you very much, Mr. Ambassador. And now we'll have John speak.
Good afternoon, everybody. It's wonderful to see so many people here today. I speak on behalf of my colleague Toby Cadman as well. It's very gratifying to see so many people demonstrating such interest in what has become for us an almost obsessive journey over the last few months to try and instill some sort of common sense into a tribunal or the preparation for a tribunal, which thus far leaves such a great amount to be desired. Before I start, I must thank the American Society of International Law for having us. It's a privilege to be present at such an august institution, but most of all, I think it's only right that we record our thanks to Ambassador Rapp, because there is no doubt about it, he has had a significant effect, and he has made, he's rendered significant influence in slowing everything down in Bangladesh. A train which seemed to have run away out of control towards the end of last year has at least been shunted for the time being into a siding, and it's largely through his efforts. We're very grateful for that. Of course, it's quite strange sitting alongside Stephen on the same side of the fence, as it were, because he was my, I'm not going to use the word foe, he used that word, not me, but he was my chief opponent in Sierra Leone for some, I think, 3 years, the latter part of the RUF trial. So it's nice to be on the same side, as it were, after all that time. And I also have to endorse a comment that Ambassador Rapp made early on in his address when he said, I think I got it right, he said, if international standards apply, it will mean so much more to the people and to the victims, referring, of course, to the Tribunal observing international standards in purveying justice over the coming years. I'm an English barrister, that's my background. I would normally be wearing a wig and a gown, and so this is quite a departure for me. I left those at home for this trip. I often used to surprise juries in my opening, or my closing speech rather, by telling them a little bit about my role, my job. And they were rather surprised when I opened up by saying, it's not my job to get my client off at all costs. And it isn't. You will find some defence counsel, particularly in the international field, who appear to adopt the cause rather than the case. Toby Cadman and I don't do that. We are truly independent. And I'm saying this for the benefit of anyone who may be listening from the Bangladesh government, because we've taken a bit of stick from the Bangladesh government, or certainly their press sympathetic to the government, who have accused us of being part of a conspiracy, blah, blah, blah. We're not. I can remember that in one of the first times I appeared at the Old Bailey, I'm sure most of you have heard of that court in London, the judge made a comment which I'd never heard before. I'm sure a lot of you are probably familiar with it. Let justice prevail, though the heavens may fall. I didn't quite understand what that meant, but as time went by, of course I got it. Justice, fairness, at all costs. We must not save anything. We must not blanch at any expense in order to ensure that justice, fairness is not only done, but is seen to be done. And the reason Toby Cadman and I are involved in this case is to try to do our best, because we can't do any more than that, but to do our best to ensure that whatever happens is independent, is impartial, and it's fair. Because as Stephen Rapp said, if international standards of fairness are observed, it will mean so much more to the people and to the victims, because there were victims. I'm not going to sit here and contest the fact that there were atrocities in Bangladesh in 1971. And let me also say, I'm not going to sit here and say there shouldn't be a trial. But whatever trial there is has to be fair and has to be consonant with current international standards of fairness. And it goes further than that, because one of Stephen Rapp's main objectives in Sierra Leone was legacy. The legacy really refers to reconciliation. This is a country that wants to become at ease with itself after years of being rent apart by hatred and violence. There are wounds which need to be healed. You can't heal those wounds if you coerce justice to do what you want to do, or to enact, or rather to realise your political ends. Because I'm afraid I have to say, being as objective as I can be, that the tribunal that's been set up in Bangladesh has all the hallmarks of a political show trial. And I will explain why. Something that really belongs back in Stalin's era in the 1930s rather than something in modern 21st century. And the government have a duty to legacy. They have a duty to the people. They have a duty to themselves. If this tribunal is enacted fairly and properly, it might bring closure on years of misery. It might heap praise and respect upon the government. It might place Bangladesh at the forefront of those pioneers in international criminal justice. It may set a magnificent precedent. But if you don't do it properly, it's not worth doing at all. If you don't do it properly, the precedent that is set is terribly dangerous. So what exactly am I referring to when I say it's a political show trial? Well, I don't want to be sensationalist. I'm not going to use those words again. I simply want to give you some examples of what the International Crimes Tribunal Act allows, and you can make up your own minds. And if I'm being partial, if I'm being unfair, if I'm taking anything out of context, then I welcome people to challenge me, because I want to be put right if I'm wrong. Ambassador Rapp has talked about the definition of crimes. I want to touch upon those to start with, and use this as an example as to why this tribunal necessarily has to have an international outlook. It cites crimes such as crimes against humanity, but it doesn't define them. And as Ambassador Rapp has said, the crimes against humanity were probably largely drawn from the old law in Nuremberg and Tokyo. But things have moved on since then. There is no reference in the Act to the definition of crimes against humanity. There's no reference to the need to prove something that's widespread or systematic and is an attack on the civilian population, for example. There is veiled reference to what we would these days refer to as joint criminal enterprise, the criminal mode of liability that is so often used in tribunals these days and has become a subject of great debate. There is no definition of the ingredients that need to be proved to sustain allegations of command responsibility, and yet that is cited in the Act as a way by which people can be convicted. The tribunal needs international assistance. It needs to have recourse to precedents, cases already ruled upon in international tribunals over the last 20 years in order to understand the very terminology that it propounds in its own Act. It needs international counsel, whether in court or behind the scenes. We're not particularly fussed about that. Obviously, we would love to be in court to do our jobs. But it needs international expert assistance, because this trial claims to be trying cases according to international law. It's as simple as that. It needs provision for training, not just for lawyers, but for the judges, who are equally, and I say this with all respect, uneducated in terms of the international concepts or legal concepts that the Act appears to be introducing. It requires monitoring. Why? Not as a disrespectful blow to the institution, but because all tribunals have to be monitored. They all are. And it's through monitoring that a tribunal can make sure it stays on the straight and narrow. It's through monitoring that a tribunal can ensure itself against negative press, if you like. It's monitoring that ensures its integrity. Let me just deal with some of the... I said you can judge for yourselves as to whether or not you feel these things are right. I just want to go into some of the provisions of the Act and to talk in particular, to start with, about pre-charge. Now, you may or may not know that some of these detainees have now been in custody for 10 months without charge. The five that I represent, were all arrested on separate matters, trivial matters, nothing to do with violence against the person or anything like that. I say trivial, some of them might have been to do with dishonesty and what have you, but certainly not related to violence and nothing related to crimes that are now 40 years old. Arbitrarily arrested on other matters, then rearrested once in custody for things to do with 1971. We don't know what yet, because there hasn't been any prior disclosure whatsoever. The detainees haven't been served with a single piece of paper detailing what it is that they're likely to have to contest later on. There is, therefore, from the word go, no opportunity for a defendant or a prospective defendant, because they haven't been charged yet, to even think about preparing their defence, because they don't know what it is that they're facing. Now, that is how it is, I'm afraid. It goes further. Interrogations have been taking place recently, and why not? They've been in custody for long enough. It's about time they were actually given an opportunity to put their side of the story, except where I come from, and no doubt where most of us come from. If you're in police custody, if you are going to be questioned about an offence that you are suspected to have committed, you're usually given the luxury of some advanced disclosure as to what it is you're going to be asked about. And given that these people are likely to be facing crimes such as genocide, it might be helpful for them to know what exactly they're supposed to have done. And B, for them to be attended by a lawyer. During the interrogations, lawyers are not allowed in the room. They're not even allowed to see what's going on in the room. They are unable to prevent the investigator who's been conducting the interview from holding a spontaneous press conference halfway through the day and addressing the waiting press, announcing how the defendant or the detainee has confessed to genocide and to all manner of other crimes. But there's no formal record of the interview. And when the suspect is visited finally by his lawyer the next day, he says, "I never said any of these things. I did what you told me to do. I said I've got no comment to make." Well, let's just for one moment accept, which we are assured didn't happened, and that is that a suspect confesses everything in interview. What right does the investigator have to go to the waiting press outside and spill the beans as to what has been going on during what must, in ordinary circumstances, be a confidential interview? How does that impact upon the fairness of a trial? How does that impact upon a defendant who may later on say, "Well, actually, I never said those things. I want to go for trial." "Oh, yes, you did. You admitted everything." How does that impact upon the fairness of the process? How does that impact upon the perception of the general public? In other countries, that would never be allowed to happen. The trial would be stopped by the judge immediately. And what's more, is it not a contempt of court? But nevertheless, that's what happens. I've been told I've only got about 4 or 5 minutes left, so I'm going to have to push on. The trial itself, is it independent? Is it independent when, from bottom up, all actors are appointed by the government? The investigators, the prosecutors and the judges, all appointed by the government. Is it right that the tribunal or the Act should deny defendants any chance of challenging or making interlocutory challenges to other courts? It's ruled out. Is it right that the defence should be called to prove beyond reasonable doubt the existence of an alibi or any other specific fact in the course of their defence? Is it right that if the defence should call a single witness, the prosecution are entitled to address the bench last when it comes to speeches? Is it right that the judges have an unfettered right to question witnesses, the defence with no right of re-examination after that questioning takes place? Is it right that rules of evidence, traditional rules of evidence, should be specifically ruled out from the trial, such that, as stated by the Act, the judges may take judicial notice of what is contained in magazines, press reports, newspaper cuttings and television reports from the time? It becomes trial by rumour rather than trial on the evidence. And is it right that the prosecution can get away with serving their case papers on the court just 3 weeks before the trial, where there is no specific requirement in the Act for the defence to receive any disclosure, any statements, any evidence at all before the trial starts? But bearing in mind this is a capital case, that's what we have. I want to just wrap up now, and I want to talk about the context. The Awami League won a landslide election victory in the end of 2008. One of the central planks of their manifesto was that they were going to have this trial. After they won the election, they swiftly acted. The original plan was that members of armed forces should be tried, and 195 Pakistani soldiers were arrested, tried, but pardoned in the early 70s. The whole thing was put to bed. And there was generally a pardon issued by, I think it was Presidential Order number 16 of 1973. Everything was put aside. But what happened in 2009 was that the government woke it back up again and issued an amendment to the Act that said we can now try individuals. The individuals have one thing in common. They're all luminary members of the opposition. And now you start to see this may be a politically motivated trial. There's a constitutional article, and I'm going to finish on the Constitution, that says, and it's Article 31, to enjoy the protection of the law and to be treated in accordance with the law, and only in accordance with the law, is the inalienable right of every citizen. The constitutional amendment contained within Article 47, I haven't got time to go into the detail, but it explicitly rules that out in terms of those charged under the tribunal. So not only the rules of evidence go, but constitutional rights under 31, 35 and 44 go as well. So my final word is this: the constitutional point is absolutely paramount. And where I beg to differ respectfully with Ambassador Rapp is here. It's all very well to encourage the government to tinker with the rules and try to bring things up to common day standards within the rule framework. But unfortunately, the rules will always be subservient to Article 47 of the Constitution, which explicitly rules out any safeguard, any protection for those facing prosecution within this tribunal. The Constitution has to be amended. Without that, we have to trust a prosecution authority that has already shown itself to be fundamentally flawed and tainted by political motive, leaving a dangerous and pernicious constitution dominating a tribunal that, at the moment, can only lead to disaster. I think I've gone over time. I'm stopping there. Thanks very much for listening.
Thank you very much. Caitlin.
Thank you. And on behalf of the International Centre for Transitional Justice, I'd also like to very much thank the organisers for inviting us to participate. Maybe just a quick word of introduction in terms of ICTJ's interest in these proceedings and our role so far. ICTJ has works in over 30 different countries in which there are active debates, efforts underway to address the legacy of past massive human rights violations. We provide technical assistance in some cases, but we also bring to bear comparative lessons on the challenges of these types of processes. And I think one of the striking features of what is happening in Bangladesh is that may be striking for those in Bangladesh grappling with this challenge is that they're very similar challenges to those that have been faced in many other places, particularly those trying to deal with the legacy of crimes that took place so long ago. So ICTJ has been following the process fairly closely for the last a little over 2 years, really since the announcement was made that there was going to be a process underway. We've conducted several missions to Dhaka. I myself was there a year ago, and we are in discussions with a range of actors on the ground about resources that we have available and that may be of interest and use. I wanted to step back perhaps a little bit from some of the details that both Ambassador Rapp and John have gone through about the areas of concern in the process, and certainly ICTJ has also voiced its concern about many of those same areas, particularly in terms of the right to be able to conduct a meaningful and adequate defence, pre-trial concerns, and other practical considerations, particularly around the role of victims and protection of witnesses and so on. So I'm not going to go into those kinds of details, although I'm happy to answer questions. What I thought might be more useful to complement the remarks that have already been made is to bring to bear a little bit of the sort of perspective of looking at this as a transitional justice exercise. And I think to start with, it's a pity we don't have somebody from Bangladesh here on the panel, because this is a country's attempt to grapple with its very complicated and traumatic past, and as you know, as well equipped as those of us who have worked in these kinds of situations in other places, there is no substitute for hearing from those who have a much more direct interest, and I hope that the discussion will offer some opportunity for that. For those involved in international criminal justice and international human rights work, I think what is happening in Bangladesh really highlights how little has been known internationally about what happened in 1971. And I've spoken to many Bangladeshis who frequently say theirs is the forgotten genocide. And it is, I think, a remarkable opportunity that has now been presented by what is happening to refocus not just attention nationally but also internationally on just on numbers alone, and there are debates about exactly the numbers of victims and exactly the details, but by virtually any calculation, this is one of the worst incidents that's taken place in the 20th century. I want to, again, just frame the remarks partly by some reflections that I think in some ways Bangladesh has been a victim of history twice. First, Cold War politics meant that the international community did look the other way when the crimes took place in the first place. And now, from an international criminal lawyer's perspective, I think that Bangladesh has become a victim of history again, in that it is trying to proceed to deal with these crimes using legislation that was adopted shortly after the crimes in 1973, at a time when international criminal law was in a very rudimentary phase. Really nothing had happened since the Nuremberg and Tokyo trials. And if you read material written by international lawyers who had been working with Bangladeshis at the time in the early 1970s, this was seen as the next big opportunity for the development of international criminal law. We are now, what I mean though in terms of being a victim of history, is that we are now looking at this process, and Bangladesh is now trying to move ahead with this process, but we're looking at it with 2011 eyes, which we should do, because there has been significant development in international criminal law and in international human rights protections since then. But it is a difficult, I think, situation for many Bangladeshis I've spoken to who have very palpable frustration that the developments and the laws being used were seen as landmark 35 years ago, and now are being criticised by international criminal lawyers for not meeting current standards. But that's the situation we have. And there is very good reason for looking at the benefits and the developments that have taken place in the intervening time, because there has been so much that's happened, not just through the establishment of the international criminal tribunals for the former Yugoslavia and Rwanda, but also other hybrid efforts and also other national efforts. The other larger picture point that I wanted to touch on is the regional significance of what Bangladesh is trying to do. As Ambassador Rapp mentioned, it's a very, there really hasn't been a lot of progress in terms of formal accountability for massive violations of human rights within the Asia region. There is not a regional mechanism, as there is in Latin America, for instance, that has really helped drive a lot of the movement towards accountability and ending impunity. You've got some limited efforts that were undertaken in Timor-Leste, formerly known as East Timor, and some very limited efforts, more limited efforts in Indonesia. And then you also have the tribunal taking place in Cambodia that is also looking at crimes that are more than 30 years old. It's also, I mean, it was a regional conflict, and I think the regional dimension of the conflict is something that needs to be borne in mind as well when you're looking at this from a transitional justice perspective. And by that, I mean whether or not these trials, in whatever form they are going forward, whether they will be enough to actually satisfy the demands for accountability of victims within Bangladesh, and that includes responses within Pakistan, within India, and it's artificial to look at this only as a situation that is affecting Bangladesh. So just to come back then to what I mean by the transitional justice significance. John mentioned that ultimately this is a process that should be aiming towards reconciliation, and I actually would take a slightly different focus. I think that one of the main benefits of transitional justice responses, both judicial and non-judicial efforts, but particularly judicial efforts, is their contribution to re-establishing a culture based on respect for the rule of law and ending impunity in a range of areas, not just in relation to massive violations of human rights. Now, reconciliation may be we may be talking about the same thing in terms of reconciliation actually being a byproduct of that. But I think the respect for human rights principles and a concept of the rule of law that is substantively focused on accountability is really where we should be seeing how this process can contribute. From a transitional justice perspective, I think it is also very important to keep in mind the role of civil society in Bangladesh and to step back a little bit from the politicised discourse that has very much dominated discussions around the tribunal. It is a politically contested process, and I can't think of any context in which transitional justice issues and efforts towards accountability are not politically contested. There were people on both sides in many other situations around the world that are also trying to move towards accountability. The challenge is to make sure that the political opening of space to do something about that is not turned into complete politicisation on both sides of the views about whether or not this process can go forward, and particularly in its current form. Civil society efforts in Bangladesh have been raising these issues for a very long time. It's not that the new government came in and suddenly announced that there was going to be a process. There had been civil society groups representing victims trying to raise these issues for very many years. And there are certainly indications that there is support, interestingly, from young people in Bangladesh for accountability in a form that they believe hasn't taken place so far. But I think the key thing as well to keep in mind is that expectations about what these trials in any context can achieve after 40 years also need to be kept realistic. And if there are hopes that this is going to be the final answer to Bangladesh's legacy of its very violent birth as an independent nation, I think civil society, government, opposition groups would all be doing very well to be thinking about what other processes may be necessary. These trials are always, as has been said, only ever going to be able to be focusing on a very small group of people and will not necessarily provide the answers or the satisfaction that many people will be wanting. And other efforts around providing space for people to tell their stories about what happened for reparation for victims and so on, may need to also be considered as complements to this process. Not as substitutes for judicial accountability, but seeing this as part of a much bigger puzzle that is still yet to really develop. But the reality of prosecuting crimes 40 years after the fact, as we've seen in many places, and I think is really at the heart of a lot of these questions about how quickly the process should move forward. Is there the time to step back and really improve the important human rights protections to make sure that this is a fair process, are tied up with this time delay. These cases, prosecuting any serious case of international crimes, are very different from prosecuting any type of ordinary crime. The scale, the complexity, the number of victims, the type of evidence you're looking at, the modes of liability, all of these practices that are developed in international criminal law have been in response to those particular challenges. And the Bangladeshi authorities and the judges who are working on this are not the first ones who have been essentially doing an experiment, trying to work out how to move forward. So I think the message about the importance of international assistance is less a reflection of the state of Bangladesh's judiciary or anything else, but the novelty of trying to grapple with these things in a national system, which many other countries have also had to face. But the other factor in looking at conducting a judicial process so long after the fact is not just the time and the complexity, but also the unpredictability of a judicial process. And for all those who I think are committed to seeing judicial accountability go forward, it's important to keep in mind that any litigation is by definition unpredictable if it is a fully independent and fair process. And being prepared to live with the fact that if it is properly conducted, and there may be acquittals, and that might be one of the most legitimising aspects of a process, that it can actually produce an independent decision from the judges tasked with dispensing the justice. So, just to sort of conclude, I really sort of want to pose the question to those who are engaged in this about why should Bangladesh proceed with these trials, and why, if they are going to do so, that it is so important to do it properly, which I think we've all kind of covered in different ways. But it's partly about Bangladesh's obligations under international law. Both obligations as a state to investigate and prosecute the types of international crimes under consideration, but it's also about respecting the rights of Bangladeshi victims as individual citizens to an effective remedy for serious violations of their human rights. And that those individual rights do also include the right to reparation as a dimension of an effective remedy. So coming back to, again, the need for perhaps a broader look at what else might be needed to complement the process. But this offers a huge opportunity for Bangladesh, I think, to use the space that has been created in terms of some political will for accountability, which is a rare moment for any country in the wake of mass crimes. It's never an easy task. But if it's not done properly, it won't be able to be seen as legitimate. It will always be subject to challenge by those who have opposed the process. And coming back to sort of the importance of the suggestions that have been made for improvement of the rules of procedure, the problems with the constitutional exception that's in place, really is that any process that can't withstand challenge will continue to be questioned further down the line. And if this is going to be a process that has been a long time in coming, then it is worth taking the time to get it right. A last thing that hasn't really sort of come up so far, but I think illustrates the opportunity that this process offers for both Bangladesh and the region and internationally, is is in relation to the types of crimes that are being looked at and the technical challenges that are required to really deal with these properly. And as many people who are familiar with the details of the conflict are aware, gender-based violations were a huge feature, and there are allegations of mass rape in a very systematic form, and this is just one small area that really illustrates how the international developments that have taken place in the last 15 years can be directly relevant to helping make that a meaningful response if this process is going to actually address those crimes. But what we have certainly seen is that if you are going to do that properly, you need specialised technical assistance, people who are experienced investigators in dealing with gender-based violations, adequate protection for victims and witnesses and so on. But the reason why this is such an opportunity for Bangladesh is that if you can set up adequate protections for this process, that can also be useful in the ordinary justice system. If you have adequate measures of support for vulnerable groups of witnesses, guarantees around defence rights and protections from allegations of torture and so on, these are all things that people have raised in the context of the ordinary justice system in Bangladesh as well. And it really comes back to this question of how do you do this process in a way that will serve its own goals of providing adequate accountability for the past while also contributing to building a much more robust culture of protection of rule of law and ending impunity in various forms within the protection of the legal system in Bangladesh generally. And I think that the challenge for those within Bangladesh who are looking at this is to distinguish between legitimate concerns about the process, which have been adequately and well articulated today, but not that they be used as a shield for continuing impunity more generally. And I think being able to distinguish between those claims is one of the hardest things that Bangladesh has to grapple with.
Thank you very much. Some very insightful and compelling discussion here. I'd like to open it up to the floor for questions, but let me start with my question to start us off here for Ambassador Rapp, which is you mentioned that you will be going back to Bangladesh and continuing your interest and commitment. And I guess I'd ask, is there a sort of a more specific U.S. commitment, and what is that to? What will that commitment look like, and what are the plans for the U.S. to stay involved and for you to stay involved?
Well, obviously, we want to see the progress on the sort of recommendations that I made to ensure that international standards are observed here, that the rights and protections of the accused in particular are protected through appropriate changes in procedures and practices. And as I have said publicly there, the United States would like to assist. I mean, we do already work with the Bangladesh legal system generally on, ordinary court issues, organized crime, counterterrorism, drugs crimes, things like this. We would have potentially some funding that we would have to seek, probably notify Congress for reprogramming it, that could be used for training of judges and prosecutors, defense attorneys, and others. And I think that's the direction that we'll go. But as I say, I've also, as I've been conducting my visits, I've been consulting with Congress because obviously they could object to the reprogramming of funds. And so, it's clear that it will be important that not as my letter put it, these were suggestions. There are other ways, potentially, that these concerns can be satisfied, but that fundamentally we reach the conclusion that standards are going to be observed in these trials, and that I can say to members of Congress that they will be observed. And then, of course, our training and involvement with the process can help ensure that in practice. But we have to, this is really a two-step effort. I think we need to go through this process of revision, and then I think we can look at the next step.
Thank you. And Ambassador Rapp, do you have any questions for the other panelists, or vice versa? Sort of give an opportunity to the panelists too.
No, let's let the audience have at us if they can.
And I'd ask that, do we have a microphone? Oh, perfect. This is all, as you know, being recorded, so if you have a question, please wait and speak into the microphone. Sir, let's start with you. Hold on one second.
Thank you very much. Thank you for organizing this discussion meeting.
And if you, I'm sorry, if you could introduce yourself as well.
My name is Akram Qadir. I'm Ambassador of Bangladesh here.
Thank you, Mr.
I'm indeed very delighted to be here today, and I thank the American Society of International Law for organizing this event, particularly because of the presence of Mr. Rapp here. Ambassador Rapp had been visiting Bangladesh. I think he has already visited twice, and I'm sure that he will be visiting Bangladesh more frequently now. See, I won't have any question actually, because I'm neither a legal expert, neither I can really represent Bangladesh as possibly one of the panel members here, or panelist is representing a particular group. I'll just have a couple of observations. The first one that actually struck me most was that in this panel I don't see anyone who is from Bangladesh representing the other side of the fence, because it seems that it's all the same side of the fence here. That's very interesting. I don't know how the proceedings will take place and how the question and answer session will be going on given this kind of a situation. Number two is that some of the panelists possibly have already made a comment regarding particular one, that the tribunal that has been created or constituted in Bangladesh, it has all the hallmarks of a politically and show trial. Now, obviously, you all have decided actually what kind of thing it will be. But we, as a representative of the government, I can assure you that we firmly believe that our judges have the qualities and capabilities, and they are capable of establishing the rule of law in the country. Now, this is a trial which is not only a commitment of the government in power, but also this is the demand of 160 million people of Bangladesh. This has been waiting for a long time now. We have waited nearly 40 years for this. And now time has come, and I'm sure that rule of law must be established. Nobody can do such crimes without impunity. We must ensure proper trial, we know it, and the government is determined to provide a fair trial, and that will be, there's no doubt about it. The third thing that I want to say is about this pardon that Mr. John Kenya has said that after 1972, everyone was pardoned. It's not the case. Joint amnesty was declared, but minus certain crimes. So obviously, the tribunal, they are competent to decide actually what are the crimes, and I'm sure they will come up with the definitions also. Now, a tribunal has been set up, and the tribunal, as the days go by, they definitely will frame required rules, of course, under the 1973 International Tribunal current times. And whatever happens in Bangladesh, these will be within the ambit of the Constitution of Bangladesh. Our parliament is supreme, and parliament to decide what law or act or whatever it is should be there in place for this. And we have every faith in the Constitution, we have every faith in the parliament and the representatives. Well, for now, I'll just say this much. Thank you very much.
Thank you, Mr. Ambassador. Does anybody on the panel, would they like to respond to that?
Yes. If I may, can I just briefly respond to that? Ambassador, I just want to re-emphasize what I said earlier on. I'm not representing a party. I'm instructed to represent 5 individuals. And as I said at the beginning of my address, my ultimate objective is just to make sure things are fair. I'm glad to hear that you have faith in the process, but I only have to refer to your State Minister for Law, Kamrul Islam, referring to the detainees, remembering none of them have been charged yet, as, quote, the accused criminals. That was in the press at the end of last week. That's not the sort of language that I think is consonant with fairness, however you want to interpret fairness. In terms of the pardon, there was a presidential order number 16 of 1973 that granted immunity to the liberation forces. This is why I say that this has the hallmarks of a political trial. It was the Bangladesh National Liberation Struggle Indemnity Order of 1973 that actually granted immunity to liberation forces. What has happened since then is that an amendment to the International Crimes Tribunal Act in July 2009 enabled the trial to take place in respect of individuals to be named, or, well, individuals, it didn't say who they were going to be, but it basically extended the ambit of the legislation to include individuals, bearing in mind Article 47, which had laid the ground for those tried in connection with war crimes to be denied all of the constitutional safeguards and rights that the rest of your constitution grants. And I read out Article 31, to enjoy the protection of the law and to be treated in accordance with the law and only in accordance with the law is the inalienable right of every citizen. That specifically, by virtue, I think, of Article 47A, is ruled out. Those charged with these offences are disqualified from the benefit of that article. Similarly, Article 35 concerning retroactivity, Article 44 concerning rights of challenge to the High Court and the Supreme Court concerning the constitutionality of the tribunal, all denied, not in respect to every Bangladeshi citizen, but only those who are charged under this Act for these crimes. For the government to come in and actually, move the goalposts and make an amendment to the Act in July 2009, which enables them to try individuals of their own choosing, denying them all the rights that I've just cited, sounds to me like something that's very unfair indeed, and more than that, it's very sinister. So that's why I said what I said.
Let me just jump in, because I want to make sure that, and indeed my knowledge of this history, though I remember living it when I was a law student and watching the reports and even seeing the day when Sheikh Mujib was welcomed back to Bangladesh in January of 1972. But in terms of the challenges that this court has, and first of all, there was mention of the 195 Pakistan officers. And no question, those individuals are outside the scope of this court. There's, as I've discussed it with the government, this is a court that's going to be prosecuting Bangladesh citizens. And those individuals were essentially sent back to Pakistan as part of the arrangements that allowed shifting of populations after the war. So this is, and some could say, well, you can't have justice unless you deal with that part of it. But in many trials, in many courts, not, and in anybody's own system, there are people that are beyond the reach of the law, and that doesn't prevent you from trying those that are within its reach. Then there's the question of the accomplices, so-called, and I can't remember exactly what the term was, but there were several thousand people prosecuted essentially for collaboration with the Pakistani forces. But their crimes weren't necessarily, I mean, there was perhaps a perception that the Pakistani forces had committed horrible crimes and these people were sort of implicated in it. But basically, their crime was fighting on the side of the nation's enemies. And though a number of them were condemned, I think only one was executed. In the end, all of those individuals were pardoned. But those cases didn't really deal with international humanitarian law. Then there's the issue of this Order 16, which I understand is generally a pardon for those that fought on the liberation side. And this certainly raises questions, and all of us that deal with international crimes, and in Sierra Leone we famously prosecuted both sides. In Rwanda, both sides weren't prosecuted. And in Yugoslavia, there's been prosecution of Serbs and Croatians and Kosovars and others. The general perception that I have of the conflict is that that one cannot cite significant crimes committed by the liberation forces, and in fact, one of the things that the accomplice statute was involved in was bringing those people into custody and preventing them from being subjected to public retribution. And so I don't think, but there could be, that there are significant crimes on that side that would justify prosecution, but one can't determine that without really studying it to a greater extent. Basically, what this court is then going to be involved with is those Bangladeshi citizens that were involved in alleged atrocities committed against other Bangladeshis, Hindus, political opponents, and others. And the statement of Sheikh Mujib was that there were 3 million killed, and there were indeed militias that were Bangladeshis that went out and killed and raped civilians, particularly toward the end of the conflict, that went after intellectuals, that went after professionals, that attempted to really decapitate Bangladeshi society before its independence. And these are horrendous crimes. That's what this court will deal with. And as it selects the targets that are available to it, what I've said is that it's important that that be done in a way that's not political, in a way that recognizes that the cases need to be selected based upon the gravity of the offenses, based upon the significance of the conduct of the individuals, with some attention to make sure that different crimes, different scenes, different parts of the country may be represented in those charges. Those are always challenging and difficult decisions, and I think because so far we're only talking about a tribunal with 3 judges, this is not a court that's going to be able to prosecute hundreds of individuals. It's going to be relatively limited unless it's intended to add a lot more. So that's why the prosecution strategy is I think, very, very important. But I don't think that because, I mean, at Nuremberg, Stalin's forces weren't prosecuted. At other places, not everyone who's guilty is prosecuted. That does not, in and of itself, prevent one from conducting fair trials of the serious cases of those individuals that are available and within the arm of the law.
I think my claim would, if I can just briefly say this, I agree with what Ambassador Rapp just said. My claim, of course, would have far less force were it not for the fact that the 6 detainees were not all very luminary members of the opposition.
Thank you. Questions? Yes. Sir.
Hi, my name is Zakir Hafez. I teach international law at SIS American University. I'm a citizen of Bangladesh. I just have some neutral observation here. I've been paying SIL dues for 10 years, so I can take at least 1 minute as a student. Every citizen of Bangladesh wants justice here. We want the perpetrators to be prosecuted. But when I see President Roosevelt, when he appointed a prosecutor, he appointed a sitting Supreme Court Justice, Justice Jackson, to show that this will not be a kangaroo court. But when I see the composition of this prosecution and the judges and the rules, the things you have talked about, Ambassador Ray, truth, independent justice, I don't see them. I mean, our Attorney General is saying that it is the golden age of Bangladesh judiciary. Simultaneously, Transparency International saying Bangladesh judiciary is the most corrupt. So how can we have justice when we know that judiciary is not independent in Bangladesh? I know if I say it's in Bangladesh, I'll be in jail now because it is so, you cannot condemn the judiciary. But just I give you one example. When the military government came in power, there was indictment against both opposition and political leaders. After this government came in power, mysteriously, all cases against the leaders of the current government have been dropped. But the cases against the prosecution are still on the bench. So what I'm saying, the ambassador, if you should tell my government, that we all, international community, want justice. We want justice. We are very grateful to Sheikh Mujib and the Awami government for bringing independence. But if it is not in accordance with the international justice and rule of law, I don't think so. It will not be a good legacy for Bangladesh. Thank you.
Thank you very much. Actually, what I said that our judiciary is not independent. Who said it?
Transparency International.
They never said it. Number one, they never said it. Number two is you said that almost all the cases of the Awami leaders have been dropped, while cases against the opposition still continue. For your kind information, cases from both sides have been dropped, as was considered necessary by the relevant committees. Even some of the cases against the opposition leader have also been dropped. But simply because charges of corruption against two of her sons still continue, so a lot of people make hue and cry, saying that, all right, but these cases are not being dropped against opposition. It is not fair. Thank you.
Thank you.
Thank you, Ambassador Rep. I'm Akhtar Hossain. I am National Director of MACPAC, Muslim American Citizens Coalition, and Public Affairs Council. I deal and cooperate with all the national Muslim organizations in the United States. As a citizen of Bangladesh, most of the leaders of the United States, some of them, they're supposed to come, they could not come because of President Obama's speech today. And they are very concerned about this situation. They're asking me what is going on in Bangladesh and how we can assist in the situation of Bangladesh for several reasons. Because a lot of things came over here after this government, specifically for terrorist extremism, all kinds of things. And now my question to you, some answer from Mr. Ambassador, some question from Mr. John. I'd like to ask you, is this prosecution or is this trial is based on political, what is your observation? Because you are working on this. And number two, how Muslim community in the United States can help to communicate or cooperate about this situation, because this is really very sensitive issue going on. According to speech from Mr. Ambassador, according to speech from Mr. John, then this is looks like two-sided and very sensitive issue from Bangladesh government. That's I want to answer from you. On the other hand, we don't want anything in Bangladesh because of this prosecution for next Afghanistan or something, wherever extremism will be developed or extremism will be happen. That's my concern over here.
Well, understand my role is to try to find ways to improve this process, to ensure that no one can say that it's politically motivated. I should note that in my meetings, particularly the meeting that I recently had with the investigators, as I discussed with them the nature of the evidence, the sort of ways in which they were building the case, I was impressed with their professionalism. But it's important, as I've said publicly, and as I've said today, that the way that the prosecution is conducted is free of politics. That the decision on who should be charged is made on neutral principles. And as I've also said in my first visit, and as our ambassador and as our assistant secretary have said during visits, these trials cannot and should not, and I think to date haven't involved an allegation that particular groups committed criminal acts. These cases involve individual responsibility. And one of the principles that came from Nuremberg, though they did have group trials there, they also had these individual trials, and the principles from the other tribunals has been individual criminal responsibility and charging people for what they did. Now, the facts, allege that perhaps people of a particular orientation were more inclined to oppose Pakistani or oppose Bangladeshi independence, and that you had militias with names like Al-Badr, et cetera, that were out there committing crimes against Hindus or against opponents of independence. Those may be the truth at the time of what occurred, but as far as, and that may come out during the course of the trial, and one can't avoid the truth of what happened, but what this cases have to deal with is whether particular individuals were involved in criminal conduct, and being an associate, being someone who politically said, I don't believe that that Pakistan should be split, or that opposed that from a political standpoint, that's not criminal conduct. People can't be prosecuted for that. If, on the other hand, people were part of an effort to attack the innocent, to kill Hindu individuals, to kill political opponents, to attack professors or others, those are crimes. And they may have done it together with people that shared certain political views, but it's the crime that they committed for which they should be prosecuted, and only for that.
Many questions. Okay, I'd say 3 more questions. Mr. right here.
Thank you. My name is Mohammed Aziz. I'm an advocate in Bangladesh and also practicing law in United States, mainly in New York. I have a very brief question to Mr. Ambassador Raab. And thank you all of you, those who are concerned about the present tribunal going on in Bangladesh. And thank you for your participation. My number 1 question on the perspective of the accused. As far as the absence of international standard like right of bail, right of appeal, like presumption of innocence, all other international standards, I just want the answer in one word, that can justice be done by this tribunal without implementing this international standard to the accused peoples? And my number 2 question, and also I just want very brief yes or no answer, that without prosecuting 195 main players of war crime, can justice, fairness be done to the victims of Bangladesh, the victims of genocide, and the victims of the Bangladeshi peoples, without prosecuting these 195 Pakistani individuals, those who are identified as the government of Bangladesh as a war crime, without prosecuting them? Can justice be done only prosecuting their so-called collaborators? Thank you.
I mean, the first point is, without observing the standards that are provided in the International Covenant for Civil and Political Rights, justice can't be done. I mean, the defense needs time and facilities, and there needs to be the burden of proof on the prosecution. I mean, if you look at the ICCPR as ratified by Bangladesh in 2000, those standards need to be protected and preserved, and they include certainly the right to bail and in appropriate cases, and that should be done. Now, I mean, we have this issue about which is a difficult one to deal with because of this First Amendment to the Constitution that put in this 47A that would indicate that some of the rights that were in Bangladesh's own constitution may not apply. But in 2000, all of these other rights were guaranteed, and I think that it's possible for this tribunal to observe those and to enforce those and to provide, through the kind of rules changes that I've said, meaningful review and relief on those issues. And that's fundamental. If that's done, I think you can have fair proceedings. And I think I answered your other question Obviously, justice in any of these courts is imperfect. Many accused persons many people who are the most responsible never turn up in court. I mean, Hitler and Himmler and Goebbels and those people weren't available at Nuremberg. There are situations where, in our own cases, I've tried people for crimes where I couldn't try the mastermind who was in some country that was beyond our reach because of extradition. I don't think that prevents you from doing justice in the case. It's perhaps not as good from the point of view of the victim not to have everybody there, but justice can still be done in that case, and a meaningful contribution to the restoration of the rule of law, as Caitlin described, can be the result of such a process.
John or Caitlin, would you like to add something to that?
In its current form, for the reasons I've described, I don't think it can be done. Ambassador Rapp is absolutely right, and it's a salient reminder that Bangladesh, notwithstanding the legislation that I've hopefully analysed today, they are parties to the International Covenant on Civil and Political Rights, 2000, and also as of, I think it was November of last year, they are a state party to the International Criminal Court. And both the covenant and the statute of the International Criminal Court give a very well-established framework of criminal justice. Not only criminal justice, but criminal justice that can be seen to be done. And I think this is an issue that the gentleman over there raised earlier on. Justice has to be seen to be done, not just done. And the problem that the Bangladesh government have, maybe now, is that there is a perception that this is a politically motivated trial. And until that perception is shifted, this is going to be replete with problems. As I said earlier on, my arguments would have far less force if it were not for the fact that whilst the liberation forces appear to have been given immunity by the order in 1973, individuals can still be picked off the street and tried nevertheless. They weren't members of the liberation forces. They all just happen to be senior ranking members of the opposition, two of whom actually served in ministerial posts in the last government. So it's a problem with perception, and it really doesn't matter what kind of legal framework you have. If you are going to pick and choose your targets in that way, or in a way which to the public at large can only appear to be partial and politically motivated, you're going to have problems with public perception and worldwide perception. And that's what we're hoping the Bangladesh government will now think twice about.
Do we have time for...
Maybe you collect the questions and then give them.
Why don't we take a couple more and then have some responses by the panel?
Thank you. This is Anis Ahmed from Voice of America. Thank you, John Kamek, for saying that it's a perception. But the question is this: should we take perception as a matter of law or not? That's a very basic question. It just happened that the few alleged war criminals who have been taken into custody belong to political parties. But these parties, particularly I would say that the major political party, BNP, has never ever said up until now that they are against the trial of the war criminals, or they seem to have said that they are politically motivated, except when one of their members were arrested. So this has to be taken with a pinch of salt, whether we try and continue interpreting it as a politically motivated case, because, you know, if we try and express our concern as a politically motivated case, then perhaps we'll be giving advantage to the other party who would really try and play this particular game of saying that it's all political. Now, to start with, War of Liberation itself was a political thing. There was a political division of opinion, but as Ambassador Rapp has rightly said that to be on the either side of the fence was not really particularly offensive as far as the ideology was concerned. But more importantly, the offense goes when the war crime was committed. And therefore, the bottom line that I'm trying to say is this, that if they belong to a different political party, or maybe opposition party, or if they happen to be former ministers or whatsoever, that doesn't necessarily prove that the case itself is a politically motivated thing.
It's a bit of a coincidence, though, isn't it? It's a bit of a coincidence, isn't it?
Well, it could be. It's likely to be a coincidence as well. But, you know, unless this is proven or unproven, we cannot really bang on the point that it is politically motivated. Thank you so much.
And one more question, and we'll have the panel respond. Sir.
Ambassador Rapp, my name is Rayhan. I have a quick question. Over 2 million, 3 million, almost 3 million people died, and over 200,000 women were violated in 1971. The question is, like, from the foreign policy perspective, that in last 40 years, has United States ever asked for justice, or has the Bangladesh government to bring justice? Because I know I read all the time human rights report on Bangladesh. Has the United States ever asked Bangladesh to bring those people in justice, like to do the justice process?
Just one from this woman right here, since we haven't had a female questioner. Thank you.
Thank you. I'm Ziba Khan. I am member of Bangladesh National Party, which is BNP. I am the executive member of BNP, and I'm a member of Human Rights Cell of BNP. Thank you very much for allowing me to speak. I have been listening to a lot of speeches, and I thank our ambassador here also, who has said few words, and some of our fellow Bangladeshis. We want justice as well, and that is from our BNP. But we also want due process so that we can reconcile and move forward, as Ambassador Rapp has put in. What we don't want is a mouse and cat game where we are just allowed to be caught so that it becomes only one-sided. As mentioned by you, Ambassador Rapp, theoretically, do you consider the legislation that only targets one side to a conflict, thereby discriminatory in intent, raises question as to the legitimacy of the process? I beg to differ, and I obviously would like this question answered, because at the moment the target is only opposition, and I fear that it is being victimized. Do you have reason, number two question, do you have reason to question the legitimacy of the process when 5 of the principal actors, the law minister, the ICT chairman, the attorney general, the principal prosecutor, and an investigator were all functionaries of a mock trial called the People's Court, Gono Adalat, which handed down death sentences to many political opponents, several of whom are now detainees? In light of this, do you think it is appropriate for these people to remain in their capacity and be able to maintain their credibility? Can I ask a few more questions? Because I'm the only female who has been allowed to ask.
That's true, and I did raise that. Just one more, perhaps.
Okay. The third one is, have you received categorical assurances from the government of Bangladesh that they will honor their international treaty obligations by raising the standard of legislation and the practice of the ICT to international standards? May I ask another fourth one?
I think after there'll be time to mingle.
Okay. Why don't we turn it back to the panel and start with Ambassador Rapp?
on these questions. First of all, if legislation were written that said that only opposition political people could be prosecuted, this would of course be a violation of any kind of standard. What I was saying is that obviously we confront the fact that there was this order providing amnesty to people that fought on the liberation side, and so those individuals, if you did have someone, and no one has cited any example of this, who committed some mass crime, they wouldn't be subject to prosecution. That limits the court's ability to do its work. However, at Nuremberg, only officers of the German government and Germans could be prosecuted, and the same at Tokyo. Obviously, those processes have been criticized, but they nonetheless were able to achieve historic justice. So it is not automatically disqualifying that you've got these sorts of amnesties that you have to work your way around. In terms of the judges' backgrounds and qualifications, it's part of my recommendation that, like the tribunals, there should be provisions for people to challenge the jurisdiction, the qualification of judges, to have those issues heard, and to have interlocutory appeal from adverse decisions. And that is an important part of a process that we should have. I'm not going to prejudge anybody based upon reports there, and all I've been talking about through all of this is to getting a fair process, not prejudging any individual, anybody who's involved in it, anybody who's accused in it, but a process to make sure that there's a way that can be done. I think the final question had to do with the undertaking of the government. I said what I had heard, that the government was very pleased, expressed their pleasure at my recommendation, said that they were going to try to take this aboard. That included, of course, my submission that they should observe international standards, that they should apply the International Covenant on Civil and Political Rights. I've taken that to be an acceptance, and now, as they say, the devil is in the details, but I'm waiting for the response in terms of what kind of rules changes are going to be made, and then we can, I think, determine whether international standards are met here, understanding that this doesn't have to be done like Rwanda or Yugoslavia or the ICC, but it still has to observe a certain minimum international standards that is reflected in these covenants that Bangladesh is party to.
Caitlin,
I guess just to respond, I guess, very, very briefly. I mean, I do think that this process, if it is to be considered legitimate, it falls in different ways. There's both the need for the processes to be able to challenge all of these questions. And if a process can't withstand those kinds of challenges, it doesn't deserve the legitimacy. But in terms of even-handedness and the questions of the pre-existing legislation, I mean, from my recollection from having looked at it, the terminology of the indemnity for liberation fighters is for acts in connection with the Liberation War. Now, there is a very good argument that should be made that if there are credible allegations that they are not legitimately of mass crimes under the definitions of international crimes, that they are not legitimately in connection with the Liberation War. So I don't see that even on the face of it, having those old acts in place should preclude an even-handed approach. That doesn't mean equivalent approach, but again, it's about having a process that in which the challenges can be raised and be determined on the basis of the evidence actually before the court by independent actors. And the question of the independence of the individuals concerned, I can't think of a single example of another war crimes tribunal where there have not been very, very similar challenges about individuals' backgrounds and individuals' participation, but they have to be able to be heard. It doesn't mean that the entire process has no credibility necessarily to be able to go forward as long as those sorts of processes, concerns can be addressed.
I think Caitlin's point is excellent. That the problem is that if someone is alleged to have committed something in the, I'll start again. The difficulty is that you cannot go to court to challenge the constitutionality or to have the fact that you've been charged judicially reviewed on the basis that there was this indemnity for acts committed in the context of the Liberation War, because if you're charged with such an offence under the Act, Article 44 of the Constitution, which allows you this right to go to the High Court or the Supreme Court to challenge the lawfulness of your arrest or your charge, is expressly ruled out and denied you by Article 47A1, which basically says the rights guaranteed under Article 44, the right to go and challenge at the High Court or the Supreme Court, it doesn't apply anymore. So I agree entirely with Caitlin. The trouble is that the framework for that sort of challenge has been eradicated for these individuals.
Thank you. And I believe we're going to have Colonel Morris Davis of the Crimes of War Project give us some concluding remarks.
Oh, thank you, and I'll keep this very brief. I'm very grateful to Betsy Anderson from ASIL and Hadar Harris from American University for allowing me to partner with them on this. I think our three organizations, what make us unique is we don't represent an interest or a client or a cause. Our interest is in the law. And so that's why we thought it was important to have this forum today. Thank you to the panelists, Ambassador Rapp, Caitlin, Christine, and John. Appreciate you coming out. Caitlin, like you, I was disappointed that we didn't have Bangladeshi representatives on the panel. We used every effort, I think, short of taking a ladder over to a window to try to get someone here, and it didn't work out. But I appreciate the panelists being here today. People have asked me, why does this matter? You know, here in Washington, why is there a concern about the War Crimes Tribunal in Bangladesh? I can tell you as a career military officer, war is hell. The law of war makes it a little less hellish. And as this tribunal contributes to that body of law, to international humanitarian law and the law of war, every little bit contributes to that body of law, and it is important to us. So thank you very much for your participation and attendance, and thank you for allowing us to have this event here.